Welcome to Employment Law class. Today we look at Section 4 of Unit 5, Capacity of Agency, Session Objectives. By the end of this session, you should be able to identify the rights and duties of agent, state the liabilities of agent. Now let's look at duties of agent to his principal. First of all, the agent has a duty to act in the best interest of his principal. So, duty to act in the best interest of the principal. Here, what we mean is that as an agent, you work for your principal. Whatever it takes for you to execute your task in a professional manner to the benefit of the principal, you have to do. Employ all the necessary skills to ensure that you have acted fairly and in the best interest of your principal. Duty to avoid conflict of interest. As an agent, you have to avoid conflict of interest. Conflict of interest can be seen from different angles. Either you have direct or indirect personal relationship with the third party in the course of your business. So any duty, either personal, direct or indirect, that will conflict your duty as an agent towards your principal, you have to avoid it. Duty not to make profit or duty not to make secret profit. Here avoid conflict of interest. Duty not to make secret profit. Here we are looking at secret profits from any dimension. Perhaps you have used the property of the owner to gain certain benefits. That profit should be accounted to the principal. You use your position to make secret profit. For instance, where you occupy, you had access to certain, because of your position, you should use your position to the benefit of the principal. Don't use your position to get benefits that should have gone to the company. The last one is a use of information or knowledge. We are talking about the fact that because of your position, you have access to certain information, and that information or knowledge should be used for the benefit of your principal. If you use this information to your own benefit, the benefit that will accrue from that information will be a secret profit, and therefore it should be accounted to the principal. Duty of confidentiality. As an agent, you own a duty to your principal not to disclose any information that has come to you as a result of you acting for him as an agent, subject to certain exceptions. Or, for instance, when disclosure is required by law, for that one, the agent has a duty to disclose those information, and he will not be in breach of confidentiality. Duty to use care and skills. So if you're an agent, you have to employ your skills in performing for your principal. Duty to account. When you are appointed as an agent, you have to keep records and account for every detail of the work that you have done, including separate account for the principal. So as an agent, don't mix your personal account or money belonging to the principal with your own money. Open separate account for your personal money and that of the principal. Don't mix them. Duty not to delegate. Delegatus non delegare. As an agent, you don't have the right to delegate the duty that has been assigned to you, subject to few circumstances. For instance, when you have obtained permission from the principal to also delegate, that one is accepted. The Latin maxim for this one is delegatus non delegare. You also have duty of obedience. Another, like an agent is required to obey all lawful instructions of his principal. However, if the instruction is unlawful, the agent has the right to disobey. Now, right of an agent. As an agent, you have the right to remuneration. That's when you have worked, you should be entitled to be paid. Right to reimbursement and indemnity. So here, whatever you have incurred or the expenses you have used your own money to pay on behalf of your principal, the principal must reimburse or indemnify you for those costs because you acted for the principal and the cost that you incurred was for the benefit of the principal. Right of lien. Here is when goods of the principal is still in possession of the agent. The agent will keep the goods until the principal pays him. That is the right of lien. The right of lien is lost when the goods are in the possession of the principal, because if the goods are with the principal, automatically you cannot seize those goods. Liability of an agent. Where he agrees to be personal liable, there creditor agent, or where by custom to the trade he can be held personal liable. We are saying that as an agent, there creditor agent simply means that an agent who has promised to pay the amount owned by a third party, in case the third party fails to pay, the agent will be liable if the third party fails to discharge his or her obligation. As paid agent, if he fails to exercise proper care, he has to compensate the principal. So as an agent, if you fail to exercise proper care or you conduct your principal's business anyhow and losses and the principal incur losses, you have to compensate your principal. Also, when he pretends to have authority, meanwhile he does not have the authority to bind the principal, then he must compensate the third party for such pretense. Now, you should also understand that the death of the principal have the effect or terminate the power given to the agent. What I mean that if the agent go ahead to contract, even when he has the power, but at the time of entering into a contract with the third party, the principal is dead or incapacitated. In such contract, the principal or the estate of principal will not be liable, but the agent himself or herself will be liable. Simple put, on the death or incapacity of the principal, the agent will be held liable if he entered into a contract after the event. The event is the death or the incapacity. Even though the agent did not know about the event, the agent will still be liable. And the case in question is Young v. Tony B. Here, what we simply means that A has appointed B as an agent to sell a property to C. Now, at the time B was entering into a contract, unknown to B, A is dead or has become insane, and B enters into a contract with C. Because at the time of entry of the contract, A was dead or insane, B will be liable for any breach of contract between the contract which he entered with C. Also, when he acts in excess of his authority and renders that the principal contractual liability to a third party, he must compensate his principal. So you also have to know that when he go beyond that powers. Where he signs a contract and does not indicate that he is signed as an agent, he will be personally liable. He will be personally liable. Here you mean that if the agent is signing contract, he should indicate that he is acting on behalf of another person. So here the principle of undisclosed agent comes in. The agent must not only show that he signed for as an agent, must also show that he is so authorized to sign that particular document. So if you don't indicate that you are entering a contract for someone, we presume that you are entering a contract for yourself. In this session, we have attempted to explain what is meant by capacity. We also try to describe some rights, duties, and liabilities of an agent. Thank you and have a nice day.